Hey, welcome back to Incorporate, the podcast for business owners presented by the UB Center for Entrepreneurial Leadership, the show where we explore the stories and strategies that help businesses grow, evolve, and hopefully thrive. I'm your host, Susan Steffen. I'm the Executive Director of the UB School of Management Center for Entrepreneurial Leadership, otherwise known as CEL. With me for all our podcasts is our producer, Jordan Lima. He's the founder of Lemur Studios, where we're recording today. And today we're digging into a topic that many business owners overlook, probably until it's too late. We're talking about financial and estate planning. Whether you're planning to scale, sell, or simply safeguard what you've built, today's conversation will give you expert insight into protecting your business and protecting your personal legacy. Joining me are two seasoned professionals, Dan Cavaretta from Cornerstone Capital Wealth Management, who brings years of financial advising experience to the table, and Dan Schuller, an estate planning attorney and partner at PB Elder Law. Gentlemen, welcome to the show.
Thank you, Susan.
Thank you for having us.
So, Dan, I'm going to start. Well, I can say Dan for both and be right on the mark here. Can you briefly introduce yourselves and just tell us, what do you do with business owners? What's the work that you do? Dan, you want to start?
Absolutely. So thank you, Susan. Good afternoon, and I appreciate you having us on the Incorporate podcast. So my history has always been in retirement plans, and I worked for Nationwide for like 16 years. And I traveled all of New York State, and I helped advisors put retirement plans in for their business owner clients. And in my travels, I saw that most advisors only focus on about 3 to 5 business owners. What we do at Cornerstone Capital Wealth Management, about half of our clients are business owners. So we specialize in that area. We know what business owners need, what they want, and we have solutions to help them with their issues. So primarily that's what we do. We help them grow their wealth. We help them transition it to their family or a charity if that's what they want to do. And all of that starts with making sure that they have the right legal documents, which I'm going to turn it over to Dan to introduce himself.
Nice.
Sue, thank you for having us. I appreciate it. My name is Dan Schuller. I'm a partner with Fallsgraf, Beinhauer, Greer, Harris, Schuller, LLP, better known as PB Elder Law.
Thank you.
So we work with business owners and people like Dan on the estate planning side, the legal documents. So from your basic estate planning like wills, powers of attorney, and healthcare proxies to more complex documents like trusts, asset protection documents for people that are concerned with potential long-term care costs. And then we're working alongside the business attorney to make sure that whatever the business owner is looking to accomplish on that side, the legal documents match that plan.
Gotcha. So I want to start with trying to get my head around, I guess, we're talking about financial planning and we're talking about estate planning. So how do those two come together? Like, why are we talking about them together? Why are they not two separate things?
Sure. So I would say and start with that we help people plan for the known and the unknown. And we want to make sure that we have everything planned out for what you can expect. So buying a house, buying a business, getting married, people expect to do those things. They plan to do those things. We also want to plan for the unexpected. So I call it the 3 Ds: divorce, death, and disability. We want to make sure we have a game plan in place for those things that that probably won't ever happen, but they do happen to people. We see it firsthand, and I'll go through some examples as we talk today. One of the things that I think is very important when we're discussing about this planning is titling of accounts and beneficiary information. So I saw 2 things firsthand in the last year. One of our clients, she had been divorced for 10 years. Her spouse died unexpectedly, and she was still the primary beneficiary. Whatever you have spelled out in your beneficiary designation will actually take place. So it supersedes your will. So whatever you have spelled out there will actually happen. And she got that money, and I'm sure he didn't want it that way. Another situation happened where we got a call from one of our CPAs, and he said, Dan, I'm not sure what to do here. So I'll give you the facts and then kind of guide you through what happened. So she was the beneficiary. He called us because his client, she just passed. He was doing her final taxes as well as her estate taxes. They identified that she was her brother's primary beneficiary, and he did not have a secondary beneficiary. He had predeceased her by 5 years. Nobody told the corporation that he worked for that he had passed. That money went into her estate. So basically his $1 million turned into $500,000 and went into her estate and got distributed to her beneficiaries. Wow. All he had to do was take 5 minutes and name a secondary beneficiary. It would have prevented that whole thing. Basically, what would have happened in that situation is he would have picked the beneficiaries for it to go to, and that beneficiary would have inherited that money. It would have grown tax deferred for the next 10 years. He still has to take an RMD out over 10 years. And in the 10th year, the full thing needs to be liquidated. So things like that are just simple of titling and beneficiary information can make a dramatic impact, have hundreds of thousands, if not tens of thousands of dollars difference in your estate plan.
Wow, that's amazing. So you guys work together a lot, correct?
We do.
And so when do you come in, Dan, like in terms of the legal side of it, right up front too? Or how does that work?
Most of the time when I come in is the client's meeting with someone like Dan, and Dan sees all the glaring issues that are about to happen because he says, do you have your will? Do you have your power of attorney? Do you have your healthcare proxy? The answer is no, 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 or it's significantly outdated. He's also in his business also dealing a lot of times with business owners or high net worth individuals who, if they haven't done planning, are potentially exposing themselves to issues with future operation of the business or estate taxes. So a lot of times Dan or someone like Dan gives me a call and says, hey, I have a client who has needs. Can you come in? Can you meet with them? Here's the scope. What should we do? And then we start by sitting with the client, figuring out what their objectives are, getting to know the family, and then coming up with a coordinated plan alongside someone like Dan to make sure that we're accomplishing whatever that prospective client's needs are.
Okay, so we're talking about a lot of documents. So I want to stop for a second and just kind of do some definitional things, because I know for myself, I haven't gone through a few estate situations lately. There's a lot of confusing terms in there. So first we talked about a will. Okay, so we've talked about a will, a power of attorney, a healthcare proxy. Can you just explain what those are?
Of course. So your will is your legal document that upon death directs how you want your assets distributed. Within your will, you appoint someone to control your estate, otherwise known as an executor. There are other provisions you can include in your will. If there's disabled beneficiaries, we'd want to make specific provisions for them so that we're not disrupting any benefits they may be receiving. If you have younger children, the will can address what happens in the event you were to pass and your children were still minors. You have children with spending problems or beneficiaries with spending problems, we can create situations like that. One thing that I will point out that Dan already mentioned is a will does not deal with all assets, though. And in my line of work, the goal is to never use your will. My line of work, we want assets to pass by virtue of beneficiary or through a trust. A will is only addressing individually titled documents, or assets, I should say, with no beneficiary. So if there's a joint owner, the joint owner will receive it. If there's a beneficiary, the beneficiary receives it. So the will in my line of work is not your primary planning device. It's the catch-all for something that may slip through the cracks. Your second basic document is your power of attorney, which is your legal document that appoints a financial agent for you. Someone in the event you're incapacitated or you just need help can manage financial transactions for you, from basic things like bill paying to complex retirement account transactions, filing income tax returns, really anything to do with money. And within that power of attorney, there are also broad powers that allow for last-minute nursing home planning for people with too much money that need to go to a nursing home. So it's a very critical document. And the third is your healthcare proxy, your medical directive. In the event you can't make your own medical decisions, who would you like to make them for you, and what type of treatment would you like? So those are the basic three documents.
Okay, so the power of attorney and the healthcare proxy are for when you're still alive, for people to be able to help with whether it's financial or medical decisions that you need because maybe you're not able to handle that at the moment. And then your executor is the person who's handling the estate issues after you die.
That's
right?
correct.
So there's really three, maybe all the same people, but three key people you have to figure out who can do those functions for you.
That's correct. And I think what's key to note is a lot of people that I talk with think, well, I'm married, my spouse can do these things for me. And that's just simply not true. And the example I would give is if you don't have a power of attorney and you have an incapacitated individual and the spouse calls someone like Dan and says, hey, I need to make a withdrawal out of my husband's 401k, Dan's first question is going to be, where's your power of attorney? Well, I don't have it. He's my spouse. That doesn't matter. Spousal relationship does not give you access to independently titled assets. So that's why it is crucial, especially for business owners, to have a document like that, because if they become incapacitated, who's going to stand in their shoes and start operating within the business?
Interesting. Okay. And so how often do you see people coming to you, Dan, that don't have any of that?
Quite a bit, or it's very dated.
Okay.
So many times I haven't looked at it in 10 years or 20 years, and the people that I picked are no longer on this earth anymore. So what we do is we help the business owners get organized and make sure that we have, I'd say, take inventory. So have them nice and organized, list out exactly how things are titled, if it's joint, if it's individually owned. And then we go meet with the attorney, because then they'll tell us if we need more complex planning or if what they have is proper, and if we have to put transfer on deaths on different accounts, or if IRA designations need to get updated. So we work hand in hand with Dan and his team on what we need to do there.
So if I'm a business owner that has, for my personal accounts, if I have a retirement and IRA account, I can name a beneficiary for that. And then that goes all by itself. It doesn't need, these other documents don't apply. What about the business accounts? Like, how does that work?
So the business, like anything else, should have agreements in place with respect to what happens with respect to membership interest, for example. So if you have a business owner, the question becomes, is there an operating agreement? Is there what's called a buy-sell agreement? Namely, what happens, what rights does the company have in the event this individual has passed away, to either acquire back the assets? And a lot of times what I see in my line of work, again, I don't do a lot of the business aspect of drafting buy-sell agreements, but what I oftentimes see on the back end when we're doing an estate for an individual is they come in, there's a decedent, they have a business, there is no buy-sell, there's no other agreements in place, and all of a sudden the business is going through the estate. And now potentially you have your scenario where maybe there's 3 kids who the decedent has, but only 1 child runs the business. Well, now you have 3 owners of the business because the documents were not in place to deal with that particular scenario. So that's really where we are working hand in hand with the business attorney to make sure that the legal documents on the estate planning side are matching up with the objectives of the business owner.
Yeah.
I would add to that too, like especially for like a sole proprietor where there might not be partners involved, having somebody authorized to handle the checking account just in case that person becomes incapacitated. Like having somebody authorized to be able to do that stuff is very helpful, because you never know what could happen.
Yeah.
How often should this be revisited? You're mentioning people passing away. You're mentioning things being dated. I'm sure legislation changes. I'm sure rules change. How often should people be looking at these documents?
It's a great question. So unequivocally, I can tell you that if an individual has a power of attorney from prior to 2010, it needs to be redone. There were significant changes in the power of attorney law. What was once a 2-page form is now upwards of 14 pages. And the changes were significant, mostly on the last minute planning for nursing homes, which can result in saving hundreds of thousands of dollars for people that need long-term care costs but have too much money to qualify. There can be last minute planning that's done. So as to the audience, anyone that has a power of attorney pre-2010, you should immediately be visiting with your attorney, because I don't even have to see it to tell you that it needs to be redone. On average, I generally tell my clients 3 to 5 years I would review things, but also significant life events, disabilities, deaths, divorces, the 3 Ds, that Dan hit earlier. Those are things that should require you to sit, look at your documents, and make sure they're still fresh.
You don't want your ex-wife getting your stuff.
Well, to Dan's point,
I'm writing down the POA thing right here for me, just asking for a friend.
That horror story, though, I had a client about 2 years ago who had a girlfriend at the time, named her on a life insurance policy with $1 million death benefit. They broke up. He passed away unexpectedly in a motorcycle accident she inherited. So I had to explain to the family, you can try to deal with this, you can try to litigate the issue, but he was of sound mind when he made those choices. And just because we don't like the end result doesn't necessarily mean that you're going to be successful.
I have a feeling it doesn't have a feel-good ending to it, where
It's not.
the ex just came around and didn't want the money.
It's not.
It's interesting too when I'm meeting with people on 401k plans and meeting with employees of companies, and many times that situation happens. I'm going to be getting engaged, or I'm engaged, and I try and guide people to, why don't you wait until you're married to update it? You can change it at any time, but just in case you don't actually get married and then something were to happen to you, that person's going to get your money. So I try and guide people. They might still make that decision. That's ultimately their decision. But
I'd imagine as a business owner, are you sending out reminders? Are you sending out like hey, you should maybe get a check on this? Or is that like bad for your business?
No. So we go out and do education at our different 401k plans, retirement plans, whenever they have enrollment time periods. And we help the employees hop onto the website, and we always double check their beneficiary information. Whenever we do group education, we always remind them, like, this is something you need to do. Whenever you have a major life event, make sure that you're updating this information.
I'm wondering who the listener is out there that is remembering the ex-girlfriend they have on their paperwork and making a call right now.
Well, for the business owners that are in the audience that are high net worth, I think one thing that is really key that they should be keeping an eye on is the estate tax exemptions. So right now on the federal level, as a married couple, you can exempt up to $28 million that is set to sunset at the end of this year and come back down to about $5.5 million. There probably will be a cost of a living adjustment associated, so maybe up to $7 million. If legislation is not implemented, that could bring significantly more people into the fold of potentially having to pay estate taxes. And on the federal level, it escalates up to 40% pretty quickly.
Wow.
So that is one piece of legislation or just something that's going on in the background that I would say keep an eye on. If you are a high net worth individual, make sure you're talking to your attorney, your financial advisors, because again, if legislation is not implemented, that's a significant change.
What happens on the state level for tax?
So on the state level, it's a $7.1 million exemption, but New York State has what's called a cliff tax, which means if you die owning just 5% more than 7.1 million, it's about 7.5, they tax you on the entire value of your estate, up to 16%. So there are significant estate tax planning techniques that business owners can put in place to make sure that they minimize or even eliminate estate taxes if done correctly. So if you're in those brackets, or even if you're 4 or 5 million, but you're still working, the likelihood is you're going to exceed those thresholds just with the growth in the market. So you should be talking to your estate planning attorney about how to deal with those situations.
We work with many attorneys in the area. They make sure that whatever you put on paper, they help you follow through and make sure everything is titled. They see it all the way through to the end. Most attorneys out there will do your documents for you, give it to you and say, here you go, this is what you need to do, and leave it up to you to make sure things are titled properly. And you talk to your advisor, you talk to your CPA, you talk to your different advice providers that you might have out there, your bank, your financial advisor, and make sure everything's titled. If you are a business owner, you're responsible for all that stuff unless you work with a good advisor that will take on that responsibility for you and coordinate your advice provider. They make sure if they had to go downtown and make sure documents are filed, that they're filed. And it's so important because most people get those documents and they don't follow up on it. And you might as well not have those documents. So it's very crucial to make sure that that stuff's on file. We have a client that grew from $9 million to about $20 million. And their attorney did a phenomenal job getting all their documents together. We were working with them. We got everything titled properly. We made sure everything was titled at the bank. But they had so much growth in their account, and with those tax law changes, we said, all right, we have to go meet with your attorney again, because your attorney's not calling you up and saying, what's your net worth this year? Right? So that's something that we need to coordinate and bring to the attorney's attention that, hey, we have to get back together and review this because there's an state problem, especially if the federal taxes go back to $6 million, $5 or $6 million.
Dan, I want to take a little different turn here because the one question I have, we're talking a lot about what happens at the end, we'll say, for business owners, right, and estates. But, financial planning is a lot about getting people to be able to live how they want to live as well. So the one kind of common theme I see a lot of concern with business owners, there's the business wealth and then there's their personal wealth, right? And trying to, protect both, but when does money come out of the business and go to them? And how much should they be spending? And how do they grow so that they can retire and leave that business or sell that business someday? How do you work with business owners on just growing their value, like not thinking yet about the end, but growing the value of their personal wealth and their business wealth?
Sure. And I think Dan would echo this, but if you're an S Corp, there's no reason to leave a lot of money in your business because it's subject to lawsuit and liability. So we see a lot of times that business owners leave too much money in their business. Make sure you don't have more than what you really need. Do you have an opinion on that, Dan, or do you echo that?
I echo that.
Yeah. So we start with first organizing our business owners, making sure they know what they have, because many times they open accounts in different areas. They have business accounts, they have personal accounts, they have bank checking. You'd be surprised at how many different accounts people open along the way. So we make sure that everything gets organized, we know how it's titled, and then we do a financial plan for them. So we show them minimally, this is what you need to sell your business for if you want to retire someday and maintain your same standard of living. That's what the financial plan solves for us. They may have enough saved up or they may not. If they don't, that's why it's important to start this process as early as possible, because the younger we can talk to somebody and help them understand how much they need to save to get there, the better off they're going to be and the easier it is to make adjustments along the way. So that's the crucial part, is we can help them understand how much minimally you need to sell your business for. Then from there, we call it capital needs bucket and a capital surplus bucket. So capital needs is, what do you need to do to live the rest of your life without any stress? Capital surplus is when you sell your business and you sell it for more than it's worth or for more than you need to. So you bridge that gap. What are you going to do with that surplus at that time? Are you going to gift it to your kids? Are you going to go have fun and take some vacations, take some family vacations? Or maybe you're very philanthropic. Are you going to donate it to a charity or donate some of it to a charity each year? So we love to tell our clients when they're in the right position to spend money, go take those vacations. We don't want you to ever regret anything. So don't regret that you can't take this trip anymore. Go do it now. And the best conversations we have is when they come back to our office and tell us the trips that they had with their family. Most rewarding part of the planning process.
Yeah.
At what threshold would you take on a client? What wealth do they have to have as a minimum?
Yeah, that's a good question. So typically we have $1 million minimum for us to be able to manage the assets the way we want to. But I'll give you a lot of hope for the younger generation. We've had a couple of 20-year-old clients that we took on. This one young lady, we were referred to her by her CPA. She has her own business. I won't tell you what it is, but she's found a really good niche. She makes about $500,000 a year, has her own house, all paid off, and just saves. She's nervous to buy a new car. So it's pretty cool to see that, and it's very encouraging. And then she introduced us to her sister, who also owns a successful business, pretty similar situation. And it's pretty remarkable that you see these younger generations. So in that situation, you have people that are good savers that'll listen to us, and they're good at saving. So we'll help those people too.
What about someone who's bad at saving?
That
has no money at all.
No, absolutely. And when I'm out there doing meetings at our 401k clients and simple IRA clients, I'm helping people with budgeting, with helping you figure out how much cash flow you have and understanding some of those things so you know how much discretionary income you have left to be able to save. And I always kind of repeat the old adage, pay yourself first. And that is so important. Save your money first and then spend it. That's so important to the whole successful saving for retirement strategy. If you do it the other way around, you're never going to get to the saving point. So save first, then spend what you have left extra.
What are some of the biggest mistakes that you see small business owners making when it comes to financial or estate planning? Like, what are they either don't even know that they should be doing or they're doing wrong?
On the estate planning side, definitely lack of preparation. Again, a lot of times the clients we see, they started a business, they started an LLC just to get a business going many years ago, and they're just running the business. They're just, collecting the fees, paying the bills, but they're not actually operating. They're not acting as business owners. They're in the business instead of working on the business. And what we see there is they're so focused on what the job actually requires that they forget to what happens when I pass? What happens when I want to be bought out? How are we going to determine valuations? So they are leaving out the really necessary planning to be able to take the business on to the next generation. And what we end up then seeing is, okay, there's somebody's passed away, the family comes in, there's nothing with respect to the business. Now the business ends up in the estate. With business owners who are proactively working with us, a lot of times we will use like a revocable trust, for example, to assign those corporate shares, LLC shares into a trust to take it and avoid probate. Probate's not something you want to go through. That's where we actually have to use someone's will and go through the court system. And on average, you're talking about 12 to 16 months and 3% of the value of the estate and legal fees. So by using a trust, you can eliminate time delays, you can reduce legal expenses. And then the other big one is a power of attorney. Again, you have a business owner who maybe is a sole proprietor running the business, and then there's an incapacity issue, but no one's now able to stand in their shoes and start operating for them. So those are the biggest things I see on my end is just lack of preparation.
Can you explain the trust situation? Because I think there was always a perception that trusts are just what, happens to wealthy New England families. What? And you used a couple words there,
Yep.
Revocable and irrevocable.
Sure.
Just to explain this whole trust thing and why we should have one.
So trusts, I think, in today's day and age are more prevalent than they've ever been. And I think that's because there's more community education on how they actually operate. I think what you just said is correct. That's the myth and the perception is I have to be rich, I have to be wealthy to have a trust. And quite frankly, the majority of my day, I end up spending creating Medicaid protection trusts for people who are concerned about long-term care costs, that they want to make sure their house is never available to pay for their care. So a lot of times those clients they have a house, they have some assets, but not extremely wealthy, but the house is worth something. It's worth $300,000-$400,000, and we want to make sure that if they need long-term care more than 5 years from then, that we protect it. Whereas on the revocable trust side, that is traditionally more for your high net worth earner or someone that has what's called a long-term care insurance policy, which Dan can speak more of. But it's a type of policy that if you ever need nursing home care is available as like an income stream to help pay those large $15,000 to $20,000 a month bills that the facilities charge now. But either way, both of those trusts have really one big benefit at the end, which is anything that is owned by the trust or that pays into the trust by virtue of beneficiary does not go through the court system. So you may only have a house and maybe some cash in the bank, but if we can use the trust to pass those assets on to your loved ones, again, you're saving more than a year's worth of time and a significant amount of attorney's fees because the trust does not go through the court system. It allows assets to just be paid out. A revocable trust, the owner remains in full control of their assets during their lifetime. So that's why it's more for high net worth earners, because if they need care, they're not worried about having to private pay. Whereas an irrevocable trust, you're effectively giving up the right to control the asset in the trust, which is why commonly it's a house that's going in, because you can still live in the property and you still keep your property tax exemptions. Unfortunately, you still have to pay the expenses, but you're not really giving up anything with respect to your lifestyle. So it really depends on a case-by-case basis which trust we're using, but the majority of my day, I spend meeting with clients and we're incorporating some kind of trust into their plan. So it's not a wealth-based determination. I think that's one myth that's out there. It's really we don't want to end up in the court system on the back end of this because it's just become more timely and more expensive to go that route.
Wow.
I have a level 0 question here. How does someone pay for a lawyer to be their power of attorney? Is that like we paid in advance some fee and then if something happens in 10 years, spring into action? Or is there a retainer along the way? What is the structure on that?
So power of attorney, you're not naming me, for example. So power of attorney, I'm married. I just designate my wife as my agent. As a lawyer, I almost take the position that I won't ever act as a power of attorney, just because each power of attorney situation can be different. Maybe we have to use the power of attorney occasionally, or maybe it's someone who's 85 years old, has no capacity, needs everything in their life done on their finances. So generally, when you're looking to set up a power of attorney, a lot of times it's the spouse. If there's not a spouse, it's, well, who's the next trusted person in your life? Because the document does give a great deal of authority over your finances to whoever you're nominating. But effectively what it is you sign the document, and most of the time we're just storing it away. And hopefully you never have to use it. But if you do, it's now there. Now the person can spring into action. And sometimes it's, hey, mom or dad had an accident. We're at the hospital. There's no power of attorney. Can you come immediately and sign it? And now we're rushing into a hospital. And you hope at that point they have capacity. If someone doesn't have capacity and cannot sign a power of attorney, you're into what's called an Article 81 guardianship, which is where you are petitioning a court to have the person declared incapacitated and to become their guardianship. On average, those cost about $10,000. And you have an annual reporting requirement to the court thereafter. Do the power of attorney. It's a fraction of the cost, and it's done under a much more, hey, I'm in the lawyer's office, I signed it, we're done. Lot less stress.
That's just like a close person or someone that you can pass that responsibility on. So that's not a paid arrangement. That's just
nope.
Okay.
Most of the time, you can provide for compensation in a power of attorney, but most of the time, what you'll see, especially in families, is this: it's the spouse, it's the kids as the backup. So it's not. We don't just name one agent. Most of the time, you have an agent, you have a contingency plan, and maybe a contingency plan to that. Based upon who you think is best suited to handle financial transactions.
And it also lets you make arrangements. I mean, I know just having gone through, my father passed away last year, and trying to handle things for my mother, without the power of attorney, we didn't have any documents that we should have had in place, right? And so I couldn't just go to the bank account and fix things for her. I had to bring, and she's elderly, I had to bring her with me or have her on the phone. Whereas if I would have had that document ahead of time, I could have just made the calls and handled everything, and I think made her life a little less stressful, if I would have had that in place.
Absolutely. I mean, I think it's the most useful document you can have while you're still alive is the power of attorney, just because the cost, if you don't have one, as compared to just setting one up, on average, I think most lawyers probably charge somewhere around $500 for a power of attorney. And I just told you a guardianship's going to run you about $10,000. And then every year you have the court involved in your affairs. I don't know about you, but personally, I would rather just privately handle my affairs. So anyone that walks into my office 18 or older, it's an automatic. I don't care if you don't have any assets right now. Sign it, store it away, and if we ever have to use it, it's there. So it's something, if you're 18, you should have it.
And the situation with the bank accounts, many times, depending upon the situation, it's not always this way, but many times we'll recommend having a transfer on death or payable on death on the account. So it's like having a beneficiary on a non-retirement account, and that helps, right? I mean,
Yep.
it takes care of it.
Huge takeaway. In
Right.
my line of work, the things that always slip through the cracks and end up in probate, meaning we have to use the will, are the bank accounts. Because when you go to the bank, they just simply ask you, how do you want to open your accounts, right? And this applies to business owners too. We're going to open it in the name of the business. Well, that's great. But if you don't have operating agreements and other things like that, and there's no beneficiary on the account, you end up in probate. So oftentimes, again, you go to the bank, they just say, how do you want to open your account? Well, my husband and I want to open an account, but they don't tell you can put a beneficiary on the account. You can do that. So audience members, go to the bank, throw beneficiaries on, because those are the ones people are calling me about the most frequently, because when you go see Dan, he's going to make you put a beneficiary on your retirement or your life insurance or your non-qualified investments. The bank is really generally just asking you, how do you want to open your account?
Right.
And we make them do it on the bank too. We tell them.
There you go.
Well, because your point is, number one, not that we don't love to pay our lawyers, but we want to avoid some legal fees, but we want to avoid the time, and we want to avoid the stress. I mean, all the situations that we're talking about coming true are stressful situations, right? So the more planning you can do, I think, the more you can eliminate some of that stress down the road.
And cost.
And we're talking about what happens, like, personally when people pass or when life events happen and family dynamics change, right? So people you thought you got along great with, all of a sudden there's stress. The same thing happens with business owners. So a transition happens, and maybe, y'all got along really well for the prior 10 years, but then something happens, right? And things change. So I think having these documents and maybe an outside person or people or team kind of, putting the pressure on to get these things done takes the pressure off the team itself.
Yeah, and you'd mentioned the biggest mistake. So the biggest mistake we see is you have a CPA, a business attorney, a personal attorney, you have property and casualty personally and for the business. You have a financial advisor, maybe an advisor for your retirement plan, and an advisor for your insurance, and on and on and on. And the business owner is responsible for coordinating all these people and making sure that things are moving the proper way. We say, let us take that responsibility on for you. Let us get you organized, and let us coordinate with your different advice providers and make sure that everybody's working for your best interest and making your life a little easier and your business better.
I think one of the things, too, that at least I've seen, and I have a financial background, and a lot of this is somewhat murky still to me, right? Because it's not my area of expertise. But I feel like a lot of business owners feel like they should just know all this financial stuff, but understanding that this is not anything intuitive or anything, this takes years of expertise to build. So getting some outside experts in is perfectly legitimate, and you should not know all of this. So I think part of it is being humble enough as a business owner or an individual to know what you don't know, right? Because you guys are monitoring the environment. And speaking of which, like, it's crazy right now with the markets and what's happening with legal changes and what's happening with, financial changes. You guys are on top of that. Business
Sure.
owners are hopefully running a business and spending the time doing that. So what do you say to people who are just like, things are crazy now, I'm scared, I don't want to invest my money, I want to keep it under a mattress? Like, what do you?
When we're working with our clients, we make sure that their money that they're going to need in the short term is safeguarded. It might be 1 year's of expenses as in money market earning finally now 4 to 5%, right? Where, the last 10 years you're getting 0% on money market and savings accounts. So we make sure that that's well protected. So short-term money is not impacted by what's going on in the headlines. They don't have to panic. And then the next 3 years, we also want to make sure it's conservative, but a little better type of return than that part. And then whatever's left out after that, we can be a little, I call it hedging for inflation. So I don't like the word aggressive, because that could mean different things to different people. But you want to make a hedge for inflation and make sure that you're keeping your money with keeping up with the price of goods and making sure that it keeps its spending power. So their money's there, the check keeps going into their bank account, and they don't have to panic like a lot of people are.
So for your clients that are business owners, are you handling like the growth of the business accounts and the growth of the personal accounts, or is it two separate people?
Yeah, no, we are. It's we need to do it all so we make sure that things are properly titled and that they're working in conjunction with each other. So we're doing everything soup to nuts. We're working with their personal stuff. We get their spouse involved. If there's multi-generational planning that needs to happen because the kids are getting into the business, we have conversations around that. And then from a business standpoint, we're working with their benefits. We're enrolling employees. So yeah, we do it soup to nuts.
That's actually, I mean, I'm not ready for this yet, but I'm hearing about it and thinking, wow, that's fantastic that you handle it all, because even the list of how many people to be in touch with to get advice from is exhausting.
It is.
So having an expert to handle all that is really amazing.
Well, because they probably don't all agree all the time either. So
Yeah.
I'm not qualified to maybe make sure I know who's right.
I mean, clients come in and they see me and they know how much money they have. But when I start breaking it down, well, how is it? Is it qualified? Meaning, is it like a 401k, a 403b, your traditional retirement? Is it non-qualified? How's it held? And they have no idea. So I have the financial advisor, especially when the referral comes in from a financial advisor, I want them in the meeting because they're the ones that can start telling me, well, this is how this is held, this is how this is structured, because that plays a significant, makes a big part of the decision making we're doing, especially when we're talking about asset protection, for example. We're not going to put retirement accounts in a trust. Those have their own independent protection. So identifying the type of asset is a big deal, and that's why it's great to have advisors involved, because they can tell us, this is what the client has, this is how it's structured.
So if you're a business owner who hasn't done any of this, okay, and so they don't have their financial plan in place, they're not working with a planner, they don't have any or maybe most of the legal documents they need, how long and how much would it cost just to get a basic plan going?
You can
so
talk about
on the basic side, all of our estate planning is done on a flat fee. So on the basic side, if we're just doing a will, a power of attorney, and a healthcare proxy for a married couple, you're looking at about $1,800 to do that. Whereas again, I told you a guardianship earlier is about 10 grand. So hopefully you can just read between the lines that the pre-planning is always more beneficial than waiting to have the back end work. With respect to trust planning and the funding that Dan was talking about earlier, as far as retitling accounts, that really is on a sliding scale depending on what we're really dealing with. If we have a client that just comes in with a house and we have to update a couple bank accounts, that's one price. But we have a client that comes in and they have $50 million and they have accounts all over the place and there's 5 properties, that's a totally different task that we're taking on. So with our clients, we always start with a consultation. We sit down, we look at everything, we identify what their objectives are, and then at the end of that, we've created a plan and we quote them a flat fee based upon the complexity. So they know exactly what they're getting into, whereas most people's fear with a lawyer is, when is the bill going to stop, right? I'm going to keep getting billed $400 an hour for the emails and everything else. The client knows, okay, this is the fee I'm going to pay, this is the path, this is what I can expect. It's all roadmapped for them so that, they're eased. Okay, this is what I'm investing in this, instead of that, when is it going to stop?
Yeah. And how long does that process take?
So when we're doing a trust, on average, it takes from inception, meeting with the client, it takes about 4 weeks to draft the package and get things out to the client, just because of the volume right now that we're dealing with. The client reviews it. We have them back in. We walked it through them. On the back end, the funding, which is really just as important, if not more important than what the documents say. And when I say funding, that's the retitling of the accounts or updating the beneficiaries. If there's someone like Dan involved, it moves along much quicker, because I can contact his office, here's the instructions, and Dan can do that all internally. But if I'm dealing with back offices at Vanguard or wherever else, and I got to get clients on the phone and we got to do that, that takes much longer, because you're never getting the same person on the phone. So it really depends. We try to complete the funding within a period of months, especially when we're talking about 5-year lookbacks and things like that. But it just depends on what the client has and whether they have advisors involved.
So, but we're talking months, not years.
Correct.
At the worst. And we're talking thousands, not tens of thousands generally. I know it's different for each. So either which way, that's going to be a lot less than what we're talking about with probate, right?
Yes.
Either which way. Okay.
Guys, this all sounds great. When you mentioned the numbers of, what did you say it was 1,200 or 1,800?
1,800 for a married couple, yep.
Yeah, my gut thought was, okay, that sounds about it didn't like blow me out of the water. Like,
Right.
oh my God, how could that be that much?
Right.
It's obviously not cheap, but it's felt reasonable. That was my gut check on that one. And I was actually I was very relieved to hear that because
Right.
all this stuff is so important. And it's like, oh, okay, well, there's a price associated with it. That is a flat fee that you can know what it is and not be guessing or wondering or getting in your head about it, like, oh, I want to do this stuff, but I can't afford it.
And peace of mind.
That's it, right? And I mean, clients most of the time, let's be honest, clients don't love going to see a lawyer, right? If they're going to see a lawyer, that usually means something's wrong or they need to address a problem. And the one reason that I really gravitated towards this practice area is early on in my career, I kept hearing the same things after every meeting, which is like, you can't believe how relieved I am now that we know how this is going to work. And that ability, and that's clients of all ages. That's the 25-year-old who has their first child and has no assets, but now they have the guardianship provisions in their will in place if something happens, to the client who's 90 years old and, the idea of coming to see an attorney and putting things in place is frightening, and they leave and they say, wow, I feel great about that. So it really is the flat fee basis too. It really gives the clients the confidence, again, if I'm not going to just be bled to death by attorney's fees. They know what it is. This is what to expect. I would just say, with respect to your estate planning, make sure you're working with an attorney who does this. I probably rewrite 6 out of every 10 power of attorneys that come in my office because they're not done correctly. They either don't have all the authority that I think they should have, especially for elderly individuals who may need long-term care costs, and that last-minute planning I was talking about earlier about saving half the assets. So when you're doing your estate planning, go to someone who does this stuff every day. That is what our firm does. We do all estate planning, all other law, all 10 attorneys do it. We're not dabbling in other things, whereas we see a lot of things that we end up having to rewrite because they're wrong. So just do your homework. Make sure whoever you're using is informed in this particular area so that you get what it is you're paying for.
Well, we're almost out of time, I think. So I want to end with, just give us one actionable piece of advice. So business owners who are listening and they're like, "Boo, I got to get started. I got to do something." What's one thing they can start tomorrow?
I would say now's the time to start with the planning. Like, don't wait. Don't push it off. Get started right now. Let somebody, and make sure it's somebody that you trust, similar to what Dan was saying, somebody that specializes in that part of the law. Make sure it's somebody that you trust, that they'll help you get organized, that they'll have a moving plan for you. So, when people come in, we always revisit their family tree to make sure it's updated and we understand all the dynamics happening behind the scenes. Because if all of a sudden they had a grandchild that has special needs, they can't leave that grandchild as the beneficiary. It'll screw up all their benefits that they get from the federal government. So we need to get a good understanding of what's happening family dynamic wise, and the time to start planning is now. Don't hold off.
Awesome.
Yeah, I agree 100%. And especially for those business owners, have a dedicated business attorney that's what they do. Again, for example, that's not my area. I work side by side with the business attorneys to make sure that whatever their client is looking to do, I have covered on the legal side of it. So just make sure that whatever professional you're hiring, that's the individual who's versed in that particular area so that you're getting the right things put in place.
Awesome. I think you gave Jordan a nice to-do list coming out of here. So
yes. A lot of these episodes end with me having a to-do list. Yes. And the people at home, you should too, because this is great advice.
Yeah. I mean, this episode, it's really highlighted basically what every entrepreneur needs to pay attention to, that you've built this business and hopefully you've got something of value, and now you have to protect it, not just for you, but for your family, for your employees, for your legacy, for everything that you've worked so hard to achieve. So a big thank you to Dan Cavaretta and Dan Schuller for sharing their insights today. If you're a business owner and you haven't yet started your financial or estate planning, this is your moment. This is your sign to take action. Until next time, for the Incorporate podcast, I'm Susan Steffen, and we would love for you to come back and like and share and watch the rest of our podcast episodes as they're released. So take care and take control of your future and make those financial plans and call those experts. Thank you.